Be ready. Start. The brief facts of the case are that the petitioner has filed the present eviction petition under Section 14 of the Delhi Rent Control Act on the grounds that petitioner is the owner of the property wide sale deed dated 15 September 2005. Stop. It is stated that respondents are the tenants in respect of one shop of the aforesaid property under the tenancy of the petitioner. Stop. Initially, the tenanted shop was let out to the father of the respondents at a monthly rent of rupees 175 per month by the deceased mother of the petitioner, and after the death of father of the respondents, the respondents started running the shop in question under the name and style of Vinod Sweets. Stop. It is stated that respondent number 1 lastly paid rent at the rate of rupees 3000 per month to the deceased mother of the petitioner for the period. Stop. The respondents are habitual defaulter in payment of rent as they neither paid nor tendered the rent to the petitioner despite his demands and requests. Stop. It is further stated that during life of the deceased mother of the petitioner, the property was divided amongst the brother, and shop in question came into the share of the petitioner. Stop. The family of the petitioner consists of petitioner, his wife, one daughter, and one son. Stop. It is stated that petitioner is running his business under the name and style of Jain Creation. Stop. The electricity connection is in the name of the petitioner. Stop. It is stated that the wife of petitioner, namely Sujata Jain, is running her business of handloom from the shop adjacent to the tenanted shop. Stop. It is stated that daughter of the petitioner is aged about 24 years and done final year study from Ambedkar University, Agra. Stop. The younger son of petitioner is aged about 20 years and is a student of BCom final year from University of Delhi. Stop. It is stated that after completion of study, the daughter of the petitioner is keen to start her professional practice as doctor. Therefore, she is interested to start her clinic. Stop. The son of the petitioner also wants to start his new business. Stop. The tenanted shop is most suitable shop for the petitioner to settle his daughter. Stop. It is prayed that eviction order may be passed in favor of the petitioner and against the respondents qua the aforesaid property. Stop. The respondents were summoned and were served with the summons of this petition. Thereafter, separate affidavits seeking leave to defend under Section 25 of Delhi Rent Control Act were filed by the respondents, and the petitioner filed reply to them. Stop. In the affidavits seeking leave to defend under Section 25 of Delhi Rent Control Act, the respondents have stated that the mother of the petitioner, who was the owner of the property, earlier filed an eviction petition against the respondents under Delhi Rent Control Act on the same ground, which was dismissed as withdrawn after her death in 2011. Stop. It is further stated that in the inception of the tenancy, the father of the respondents was the tenant in the suit property since 1965, and after his death in 2002, the present respondent number 2 is continuing his tenancy, tendering the rent to the petitioner. Stop. It is stated that respondent number 1 should not be the party in the present petition as he is younger brother of respondent number 2 and was never in possession of the tenanted premises and never used the same. Stop. It is stated by respondent number 2 that the documents filed by petitioner itself explain that the petitioner is the owner of only two shops bearing number 1 and 2, and petitioner has not filed any document to establish the identity of shop which is mentioned as suit property. Stop. It is stated that in the site plan filed, the petitioner is claiming on three shops while ownership documents shows only two shops in his ownership. Stop. The petitioner has not filed any title document in his favor to establish the ownership in regard of the suit property. Stop. The petitioner has not filed any documents to show that other legal heirs of the deceased mother have no concern with the tenanted shop. Stop. It is further stated that petitioner is the owner only of two shops but in possession of four shops. Two shops came in his ownership through the registered sale deed executed by the mother of the petitioner in favor of the petitioner. Other two shops came in his share after the amicable family settlement among all the legal heirs of the deceased mother. Stop. It is further stated that the fact of three shops are admitted by the petitioner, out of which two shops are in the possession of petitioner and his wife, and third shop is under the tenancy of the respondent. Stop. There is another shop in the ownership of the petitioner near the handloom shop of the petitioner, which is being run by the daughter of petitioner as her clinic. Stop. The petitioner, his wife, and daughter are running their independent shops and earning livelihood and are leading healthy lives. Stop. It is further stated that petitioner has made false and incorrect submissions not only about his alleged requirement but also with regard to the availability of space with him. Stop. The petitioner has concealed the fact that the space is in possession of the present petitioner and occupied by the daughter of the petitioner as her clinic. Stop. It is stated that son of the petitioner has not completed his studies yet. Stop. The petitioner denied the averments made in the affidavits seeking leave to defend under Section 25 of Delhi Rent Control Act of the respondents. Stop. It is denied that there is another shop in the ownership of the petitioner near the handloom of shop of petitioner, which is being run by daughter of petitioner as her clinic. Stop. It is stated that the alleged shop belongs to the brother of the petitioner and the daughter of petitioner is running clinic on rent. Stop. It is stated that the daughter of petitioner is still fully dependent upon the petitioner and his wife. Stop. I have heard counsel for the parties perused the record and have gone through the relevant provisions of the law. Stop. The Supreme Court laid down the guidelines to be followed by the courts while deciding the applications for leave to contest filed by the tenants under Section 25 of Delhi Rent Control Act 1958. Stop. As is evident from Section 25 of the Act, burden placed on a tenant is light and limited in that if the affidavit filed by him discloses such facts as would disentitle the landlord from obtaining an order for the recovery of the possession of the premises on the ground specified, with which we are concerned in this case are good enough to grant leave to defend. Stop. We are of the considered view that at a stage when the tenant seeks leave to defend, it is enough if he prima facie makes out a case by disclosing such facts as would disentitle the landlord from obtaining an order of eviction. Stop. It would not be right approach to say that unless the tenant at that stage itself establishes a strong case as would non-suit the landlord, leave to defend should not be granted. Stop.